I'd like to begin with the pledge to the flag.
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
I have two minor changes in the agenda, and that is only that there will not be an executive session or attorney-client session this evening. And with that, can I have a vote to accept the agenda?
So moved.
Made by John Merwin, seconded by
Second.
John Midwood. All in favor?
Aye.
Aye. Do we have any public comment on agenda items only?
Well, George, I have a comment which relates to item 10.
Well, that could be made at the end of the meeting in the general comment period.
Okay.
It's not on the agenda now, so
All right,
this only
fine.
applies to,
Fine.
Excuse me, George.
yes.
Since it was on the printed agenda,
Well, it has on there if necessary, and it's not,
are you meeting with council this evening?
they will be here,
Warren is here, so,
will be coming.
okay, so item 10 is still there, so I guess it would be appropriate to discuss anything related to Warren.
It will be, the meeting will be on general legal matters.
Understood.
Yeah. Okay.
Well, George, I'm sorry, I don't want to be difficult, but my comment then, if there is going to be a discussion with Warren on general legal matters, my comment relates to that.
Well, when I say general legal matters, it's in relation to things that he has for the town board.
I think what George is trying to say is that there's not going to be a executive session. The Warren will be here as an attorney,
Okay.
but we will be discussing everything in open session.
Okay, I have a comment when it's appropriate about
Yep.
that.
Okay. Any other comments? Okay, department reports. Bob, I guess you're our one person here from a department.
It's time to advertise for sealed bids for 2019. This will be for sand, gravel, stone, fuel, blacktop, coal patch. Would the board like to authorize me to advertise for those sealed bids?
The board's pleasure is,
Of course. Yes.
I think we need the materials, so we certainly would like to go out for bid. Everybody in favor of,
I'll make the motion to.
made by John Midwood, seconded by Ralph
Second.
Fidelli. All in favor?
Aye.
Aye. We don't have our representative from the police force here as of yet. We have no assessors report
No,
this
the
evening.
assessor asked me to read something.
Oh, okay.
This is the assessor's report in Captain Johnson's absence. The equalization rate. On July 19, 2018, we received a final equalization rate of 100% for our 2018 roll from the New York State Office of Real Property and Tax Services. Board of Assessment review. Earlier this year, Mr. Daniel Goldhagen was appointed to finish out the 5-year term of Mr. John Campbell. This term will end on September 30th, 2018. Mr. Goldhagen has informed me that he is interested in seeking another term. I believe that he has been an asset to the current board, and so that I ask that you consider reappointing him to the full 5-year term, which would be from October 1st, 2018 to September 30th, 2023. And then let's
Do we have any discussion on that?
I think Daniel's good. Is there a motion to accept it?
that, what,
Well-
I make
what does
that
the board
motion.
want to do?
Made by Ralph Fidelli, seconded by
I'll second.
John Merwin. All in favor?
Aye.
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 And then one last thing, under litigation, the town has been served with just one taxatory, which is an expected filing continuing an ongoing case. Thank you, Catherine Johnson, Assessor.
Okay. We have the Planning, Zoning, and Building Department report on the table. Does the town clerk have?
I have my report here on the table, but I just
Yep.
wanted to make the announcement that Dutchess County is to host, this year is the Year of the Veteran, so it's the event that marks the 100th anniversary of the end of fighting in World War I. And Dutchess County will be holding a parade on Sunday, September 30th in the city of Poughkeepsie at 1 p.m. And they invite everyone, and veterans and organizations are encouraged to participate. We also have a public notice for determination of public need. This is in regards to the Arlington Fire District that we already sent a letter of support to.
Yes.
Okay.
Yep.
And then one last thing that we were just copied on, and it was to Dutchess County, but DEC has approved the application, which needs to be advertised for the extension of the Harlem Valley Rail Trail Phase 4. So that will be in the Poughkeepsie Journal or the Hudson Valley Register-Star sometime this week.
Okay. The next thing is an update on the regional ambulance study.
Okay. So the EMS, there's, as I spoke about the last board meeting, I gave a brief, pardon me if I'm a little hazy, it's
Understandable.
speaking of EMS, my wife and I went to a wedding in Pennsylvania, a friend's wedding this weekend. And on Sunday, we were traveling back from Pennsylvania. We were in the state of New Jersey, and we were driving on the highway, driving the speed limit on the highway, and a drunk or impaired driver hit us from behind at roughly 100 miles per hour, and totaled our vehicle. And I was transported to the emergency room, and me and my wife in an ambulance via EMS. And I was very thankful that there was a paramedic on scene to, monitor my vitals, because my heart rate was very elevated, had very high blood pressure, and shook up from being struck in a motor vehicle accident. So it's a very important service that that is critical to have EMS. This year we're doing it. The issue being is that in the town of Northeast we have an excellent EMS service, but we contract with Northern Dutchess paramedics, and it's very expensive. But they do provide good coverage. They are, according to the contract, they have to show up to any call in the town of Northeast within a 15-minute time period. And whether it be a motor vehicle accident, someone's having a heart attack at their home, if they call EMS, the town of Northeast contracts with Northern Dutchess paramedics, and they have to show up within 15 minutes under the contract. And there's I believe a paramedic in every ambulance, which, in EMS there's you can be an EMT, an emergency medical technician, or you can be a paramedic. The paramedic has more training, and they're allowed to provide more advanced life support. They're allowed to provide advanced life support. And EMS can only provide basic life support. And I personally think it's critical that every ambulance call has a paramedic on board to provide advanced life support, primarily for cardiac reasons. So with that said, the town of Northeast started not town of Northeast, but the Dutchess County, if you don't mind, can you say a brief overview of how we got to where we got to with the EMS, the task force, and I'll take it from there.
Well, we started off, let me see, about a year, almost a half ago, I guess now.
Yeah.
Bugging the county executive about the requirements for having ambulance service out here. We had, when John was supervisor, had contracted with NDP for 2 years at $180,000 per year. When I came into office, that contract had expired or was about to expire, and we once again contracted with NDP at that time. The first contract was for $280,000 for the first year of the contract. The second year of the contract, the first year of the contract was $260,000. The second year of the contract was $300,000. The third year of the contract will be in 2019 $340,000. Just a little background on that. Before we ever contracted with any company, we contacted as many of the providers as we possibly could. The general idea was the same with all. It costs $500,000 to run an EMS service.
An
An ALS.
Ambulance, yeah.
Yes.
Yeah.
It costs that to run an ambulance service here for the town and the village. The only thing that brings that cost down is what the call volume is. Unfortunately, being a small town, our call volume is very small. We have approximately 200 per year, which means not only are we paying actually the cost, the 300 and which will be next year, 340,000 for the ambulance service, but also those people who are unfortunate enough to have to take a ride in an ambulance are also billed. Insurance normally will cover that. But it's for us, it was an unsustainable way of going about this. So after bugging the county for for a long period of time, the county executive, Mark Molinaro, drew together a task force to look into the various ways in which we might be able to do this. John was on that task force, and that's why I asked John to be on this EMS meeting, the conference as well.
If you want, I can jump in too. So, with going on with what George said, there's an agreement, a study between 4 towns, well, 3 towns and 1 village. The town of Northeast, the town of Amenia, the town of Dover, and the village of Millerton. Now, every municipality in the mentioned contracts with NDP individually. Now, the thought is that maybe if the goal of the study is to present an options to save money and provide at least equivalent or if not better care. So we're looking at EMS in those 4 towns, and some of the options maybe like, what if we collectively bargain? What if we come together and approach NDP and say, why don't you provide the same service, but instead of us individually negotiating our contracts, could we save money if we kind of join together to negotiate? That's just one of the options. Now this report, it's the phase that we're at now. We've just ended the data gathering phase, so we just have we are right now. We have a snapshot of what the data is, and now that data is being analyzed, and then later on, months down the road, I'll have another report for, what the recommended changes are. And then from there, this is, and just to be sure about this is not binding any of these agreements. This is simply a study to find out what the options are. And then it would be up to the individual town boards. In order for it to work, if there's an agreement between the 4 towns, or the 3 towns and the 1 village, each governing body of those 4 municipalities would have to all agree and vote to adopt something. So, it's a study, and I'll have further presentations when we have more information.
But then there is a plan to, hold meetings.
Yes.
Right.
For the
The public
public.
will certainly be brought into the
Right,
process.
there will be, probably at the Amenia Town Hall sometime within the next 2, maybe 3 months. In that time period, there will be a public meeting where all residents of the 4 municipalities are invited to attend, where we will present this and have a public forum. So, but that's coming down the road, and right now we just finished the data gathering stage of the study.
I might just add to that, and this is very brief because it's certainly a future prospect. But the total amount that was allocated for the study was $190,000. Out of that, $40,000 goes for the study that between the towns here on the east side of the county here. Dover, Amenia, Northeast, Village of Millerton. In the future, the objective with the rest of the funding is to take a look at what the prospects are for doing something on a county-wide basis. And that is something that will have to be looked at in the future. It's certainly not something that would happen quickly. There are legal challenges, laws that will have to be changed. So we have to wait and see what happens on that. But for us as a small town, that prospect probably has more appeal than even on our local combination of the 4 towns here.
Right. Now, I will conclude with this study in no way will be done in time for the 2019 budget. So, yes, the EMS for the contract with the EMS with NDP states that it will increase from, I believe, 310,000 to 340,000.
340, yes.
And that's not a bad deal, to be honest. And I think you need to provide EMS, in my mind anyway. You legally do not have to. A municipality in New York State is not legally required by New York State law, I believe,
That's correct.
to provide EMS. But the town board feels we should provide EMS to the town of Northeast. So we will, even though it costs $30,000 more per year, I think it's a critical function to provide life support and emergency medical transport to the residents of the town of Northeast. So we will likely, I don't want to speak for the board, but we will likely adopt that, we're going to provide EMS in 2019 for the town of Northeast. So I'm not going to speak for the rest of the board, but.
No, each town is required to provide fire service. That is by state law. However, ambulance service is not a requirement. The only requirement is moral.
Dave Rudin is here.
Okay, with that, I think that wraps up our
Yeah.
ambulance. Dave, you want to jump in here and give your report, please?
Good evening, everybody.
Evening.
So I presume that you shared the press releases. That was about as much fun as I can take in one weekend. Hope everybody's aware of that. I won't go through that again. But for the month of July, we had a total of 72 incidents. Most of that, I would say, is probably traffic. We had 40 in the village, 32 in the town. Our arrests were actually about on par with what I would expect in the summertime, which is 4 arrests. You remember 2 of our months were sky high through the roof with DWI and DWAI arrests. So that's about on par what I would expect. Last year for 2017, we had a total of 40. I believe I attribute that to not having somebody on during the daytime during the month of July for traffic safety. So that obviously increased the numbers by quite a bit. So 2017 was a total of 40, 24 in the town, 16 in the village, and we had 4 arrests, 1 in the town, 1 in the town and 3 in the village for 2016. All the arrests this last month were actually in the town, nothing in the village.
We're getting up there, huh?
Well, again,
It's a major increase.
I think this last month was, other than some bizarre things that took place.
Yes.
I think it was a normal month outside of those 2 incidents that I reported earlier to you guys. Did you have a question?
I want to comment that I read in the Millerton News that the Millerton Police Force arrested a teenage drug dealer from Columbia County that was dealing drugs in Millerton.
Correct.
I just want to thank the police force for their good work in doing that.
Yes, that was Sergeant Veeder. He, again, and that's done through traffic stops. That's what they teach in police school. The more, the more stops you make, and again, I don't like to be stopped any more than anybody else, but that's how you derive things like that is, it starts out as being a simple traffic stop, and one thing leads to another, and you come out with a car full of drugs. And yes, that was, in my career, that was pretty substantial. I would say that's probably tops anything that I've had.
Right, and it's likely that, he was a 17-year-old? Or
18 years old.
So it's likely he's selling drugs to Weebtut high school students. So that was a big victory to, arrest him and.
There were statements made, and I can't get too
Sure,
into the details of
yeah.
that, but basically he alluded to the fact that he was in sales. Didn't say anything about the high school specifically.
Sure, and that's, I don't want to, I'll say no more, but
Yep.
thank you for their good work and.
Thank you for your comments, and I will certainly pass that on to Sergeant Veeder. He definitely great job, and I'm very pleased that he did that. Got a lot of drugs off the street. So
Very good.
Do we know what kind of drugs?
I heard the comment. About a pound and a half of marijuana. Again, these are not exact measurements. They're in Albany right now being tested and weighed. But we're pretty confident that the drug types were correct. And that was statements made by the person that we arrested. But about a pound and a half of marijuana, multiple hits of acid, which is a felony. Even for one hit of acid is a felony in New York State. And then I don't have a weight, but it was a large amount of marijuana wax, which is almost pure THC, which is what makes people high when they smoke marijuana. So it's in that, any possession of that also is a felony. It's not, there probably is some type of weight, but pretty much anything that you possess in that quantity would be a felony. But this was a pretty large sheet. which I don't think they put that in the paper. I sent.
I did read that.
Yeah,
I read
they
that acid, sheets of acid, and, you know, the marijuana.
Lava wax.
Yeah.
Yep, it was pretty substantial, so.
Yeah.
Very good.
Thank you.
You're very welcome. Hope everybody has a good evening. We'll see you next month.
Chris, can you give us an update on Climate Smart?
Yeah, I talked at pretty great length the last meeting about this Climate Smart community program of New York State, which the town of Northeast, in conjunction with the village of Millerton, has joined. Both the town and the village are now registered Climate Smart communities. That's really the easy thing. All you have to do is pass a resolution saying you are, and you become one. But to become a certified Climate Smart community is much more involved, and there are many different steps which the town and the village would need to take, and which other communities across the state have taken. There are something like 230 or 240 communities across the state that have joined this program. Only about 18 of them have actually gotten to a certified level. But getting to that level, first of all, does all kinds of good things for the environment and for the community. It also puts the community at the head of the line for grant applications down the road. So it is it's a very worthwhile program. It's essentially all carrot. None of this stuff is being mandated by the state. It is, these are actions that the town and the village can take, and for which funding can be sought from the state to implement a lot of these. So we've applied for 3 different programs for funding for 3 different programs under this. There's a menu of I'm going to say 60 or 70 different items which are things towns and villages can do. The 3 that we've applied for are, one is a study of town plans and policies, town and village plans and policies, to see to what extent that they're appropriate and sensitive to climate issues. Most municipal policies were written quite a long time ago, before anybody was really thinking about climate issues. The second is would be a study and a measurement of town and village greenhouse gas emissions. We have these municipalities, we have trucks, we have buildings, we have equipment, and we have lights, air conditioners, all kinds of things. And this would be a study simply of to what extent are these items contributing greenhouse gas emissions. This is just municipal equipment and buildings. A future possibility is then to go out and find ways to engage the public in measuring and lowering greenhouse gas emissions. A third item is a study of all the road stream crossings in the town and the village. And this is I think a really interesting thing. It is a study of every single culvert and bridge where water passes under. And it's a study not only of the degree to which they are robust and in good shape, but also of whether they have a capacity to handle larger volumes of water that might result from climate change, from greater floods and so on. It also would study the degree to which they are appropriate for fish passing through them. Anyway, those 3 programs we have applied for. We got this application in with a lot of help from the Conservation Advisory Committee and from Lisa and from Housatonic Valley Association. We got in on time. The total budget of all these 3 programs is about $59,000. There's a match requirement, which the town and village have already appropriated some funds towards. The match requirement is for $12,500, and they've $7,250 has already been appropriated for it, for the match. and we anticipate being able to meet the rest of the match with volunteer hours and private contributions. This application, the state will take its time looking at it, but we hope to hear back by December the results of whether we are going to get this. Dover has done a lot of work in this area and has gotten significant funding for programs like this. So if we do get this application, and I hope we will be successful in this, this will be something that won't start won't see till next year.
Chris? The fact that the town is working on this solar law, won't that affect,
Yes,
help us get this
that by
grant?
itself will earn us credits. And all of these programs have a certain number of points associated with them. And these programs will get us a certain number of points. We got some points for simply sticking up our hand and saying we want to be in the program. But you have to get 120 points to become a certified community, and that's a multi-year project.
Next is submission of CDBG ideas. Every year, HUD provides certain monies for grants for towns. That's provided through the county. Anyone who has ideas that may be usable for the CDBG, we're certainly open to listening to. We currently have one that has just been awarded. It just came out that for a project that we and the village went in jointly on for making both village and town hall ADA accessible. We have, I believe the total is $186,000 that has been granted, which is the amount that we asked. We didn't believe that we were going to get the full amount, but fortunately we have. So we will be starting on that in the near future here. So we're working now on ideas for the end of this year, next year. We're also in touch with the village on this. We have some ideas that the village has some issues that may need remediation, and we are discussing the possibility of going in jointly again with them. It's always better to go in jointly on these. You have a much better chance of achieving your goals. So I'd like to set a date for the public hearing as our next meeting, which is September 12th. September 13th. And for 7:15. Can I have a motion to?
So moved.
Second.
Motion made by John Merwin, seconded by John Midwood. All in favor?
Aye.
Next is the introduction of the solar law, and we'll also be setting the date for the public hearing on that. I believe you have in your information there. I have sent, I believe, everybody copies of the solar law, which Warren has had a chance to look over and has made some changes, some corrections in there. So Lisa, would you like to read the resolution for that?
It's a resolution commencing the local law adoption process for local law entitled "A Law to Regulate Solar Energy Systems." Whereas the town of Northeast has determined that it is in the best interest of the community and its citizens to provide for and encourage renewable energy systems and a sustainable quality of life, and to that end, that a local law should be adopted to provide for the permitting and establishment of solar energy systems and facilities within the town of Northeast. And whereas the town board has appointed a committee to work with the attorney to the town to produce a proposed local law to regulate such energy system within the town. And whereas the committee, with the assistance of the attorney to the town, has drafted a proposed local law to regulate solar energy systems and submitted it to the town board. And whereas the town board has reviewed the proposed local law and determined that the law is acceptable for purposes of commencing the local law adoption process, and whereas the town board has determined that this is a type 1 action under seeker, and that the town board is the only involved agency in the seeker process, and whereas the attorney to the town has prepared a part 1 of a full environmental assessment form to be utilized by the town board in conjunction with its seeker review process. Now therefore be it resolved that the town board hereby declares itself to be lead agency with regard to the seeker review of this local law, and declares this action to be a type 1 action under seeker. And be it further resolved that the town board hereby schedules a public hearing on the adoption of local law. This one will be 2 of 2018 for September. Our next meeting, the 13th at, and what time do you want to start this at?
Why don't we put 7:20?
Make it a little later, yeah.
25?
Yeah, 7:25.
7:25 at the Northeast Town Hall, and be it further resolved that the town clerk is hereby directed to post and publish notice of said public hearing in the town's official newspaper and on the town's website, and to provide such other notice of said public hearing as may be required by law. And be it further resolved that the town clerk is hereby directed to forward a copy of said local law to the Dutchess County Department of Planning and Development for its review pursuant to Section 239M of the General Municipal Law, and to the Northeast Planning Board for its review and comments in accordance with the town code. This motion was offered by
So moved.
Made by John Midwood, seconded by Chris Kennan. All in favor?
Aye.
Aye.
do a roll call. George?
Aye.
John?
Aye.
Ralph?
Aye.
Chris?
Aye.
John?
Aye.
Okay, good.
Just a couple of things on that, just,
Sure.
you have the part 1 of the environmental assessment form.
Yes.
We're just accepting that pursuant to this resolution. That has to go, to the county. You can also send it to the planning board if they want to see it. And we'll do the environmental review after the public hearing. I don't know whether it'll take 1 meeting or 2 meetings. And I think it's better to get the input on the law before we do that. And I prepared for you, just so, and for the convenience of the committee, I converted this to an amendment to our town code from the local law that was prepared, and made some minor tweaks to the law. So there's a red line copy, so if the committee wants to see what I changed, you can see that also.
Changes are fine.
Okay. And that's all I have to say about that.
Next is the introduction of the local law to exceed the tax cap. Annually, we face the issue of having to increase our ambulance fund, as we had discussed before. There is going to be an increase next year, whether we like it or not. So that may well put us over the tax cap. So I'd like to introduce the local law to exceed the tax cap, and set a public hearing for that, which will be September the 13th at 7.
Do you want me to read this resolution?
Sorry about that, yes,
Okay.
I do.
Resolution accepting a proposed local law to override the tax levy limit for fiscal year 2019 pursuant to General Municipal Law, Section 3C, for commencement of the local law adoption process. Whereas the town board has determined that it may be necessary for the town of Northeast to exceed the limit on the amount of real property taxes that may be levied by the town of Northeast pursuant to General Municipal Law, Section 3C, for fiscal year 2019. Be it further resolved, the town attorney has prepared a proposed local law to override the tax levy limit for fiscal year 2019 pursuant to General Municipal Law, Section 3C, and the same has been reviewed and approved by the town board members. Now therefore be it resolved that the town board hereby accepts the proposed local law for year 2018 entitled Local Law to Override the Tax Levy Limit for Fiscal Year 2019 pursuant to General Municipal Law, Section 3C, for commencement of the local law adoption process. And be it further resolved that the town board hereby schedules a public hearing on said local law to be held on September 13th at the Northeast Town Hall at, what time did you want that to be?
7:35?
7:35 PM, and that the public hearing be duly noticed by the town clerk as required by law. And then I just need a motion to approve that.
I make that motion.
Made by John Merwin, seconded by...
I've got just a question on this.
Sure.
The hearing is coming in September, so does this local law not take effect until the public hearing?
The local law does not take effect until we have the public
Till you
hearing.
pass it, yeah.
Until you
this is
pass it.
public
Yeah, you have to
hearing.
pass it.
Okay.
And this law, by the way, Chris, doesn't mean necessarily, although most likely, you may have to exceed the tax cap, it just allows you to.
Right, okay, I understand that. I just was trying to understand the sequencing.
Yeah.
We get
No.
into the budgeting, we're gonna try and keep
Right,
it down.
exactly.
Well,
But,
But if you don't pass the
But-
law,
the thing is, almost all towns pass this because if you don't, then you're unable to exceed the limit, and oftentimes,
If you don't,
It's-
if you don't exceed the tax cap, we then rescind the local law so
Yes.
people can get those refunds.
Right.
And we have another resolution at the public hearing.
Okay.
That says that we're accepting the local law, that it'll be adopted.
okay. I had a motion, I believe, from John Merwin, seconded by
I'll second it.
Chris Kennan. All in favor?
George?
Aye.
John? Ralph?
right, yes.
Chris?
Aye.
And John?
Okay, next, Warren,
Okay, so
things for us, I
a
believe.
number of things, I'm gonna try to do them all in open session with you tonight. So you have to bear with me a few minutes. The first issue was you had asked me to look into the issue of domestic partners and to what extent they could be covered under our insurance
Yes.
policy. It's my understanding that we have a plan which will cover domestic partners if we decide that we want that to happen. And I think the cost was $65, something like
No,
that.
actually, Lorna, do you
remember
remember what the cost exactly on that was?
It's whatever the rate is for employees and spouse, it's the same for employee and a domestic partner.
So if you decided that you wanted to do that, you could. The more difficult issue is to determine what qualifies as a domestic partner. It was my understanding that at one time, the insurance company had their own definition, so it'd be helpful if we got a copy of that from the insurance company. I'd like to see what they had. But I've looked into it, and it looks like there is a kind of an accepted definition. For example, under the public health law, a domestic partner means, and this is for purposes of disposition of the remains of the other domestic partner, but it has a definition of domestic partner. It says is formally a party in a domestic partnership or similar relationship with the other person entered into pursuant to the laws of the United States or any state, local or foreign jurisdiction, or registered as a domestic partner of the person with any registry maintained by the employer of either party or any state, municipality, or foreign jurisdiction. So New York City has a domestic partner registration law. You can register under that. We don't have one here. Or is formally recognized as a beneficiary or covered person under the other person's employment benefits or health insurance, or is dependent or mutually independent on the other person for support as evidenced by the totality of circumstances indicating a mutual intent to be domestic partners, including but not limited to common ownership or joint leasing of real or personal property, common householding, shared income or shared expenses, children in common, signs of intent to marry or become domestic partners under this paragraph. So that's the way it's defined under that section of the law for purposes of disposition of the remains. I found another sort of standard, well, that doesn't help. I found a lot of stuff, but. So state employees and civil services recognize that you can insure domestic partners under your insurance policy, but you're not mandated to do that. Now, it's different if you have domestic partners who are same-sex couples who are married. Those have to qualify, but not for persons of different sex. That's what I found in the decisional law in the state of New York. It's discretionary. As I said, it's not mandatory. And in New York, this is what generally is the guidance that I could find. Both partners, as I have reached the minimum age, usually 18, neither can be related by blood closer than what is permitted for marriage in that state. The partners must share a committed and exclusive relationship. The partners must be financially interdependent. And you as the employer can and should require some sort of documentation to prove that relationship, which may be as simple as having them sign a written statement or provide documents showing the demonstrating these factors and the interdependency financially. Some other guidance that I found in New York: to register, both you and your partner have to be New York City residents, so we would certainly require them to be Northeast residents, and one of them has to be employed by the City of New York. We would require that. Both persons 18 years of age or older. Neither you or your partner is married or related by blood in a manner that would bar his or her marriage in New York State. Both of you have a close and committed personal relationship, live together, and have been living together on a continuous basis. The same language used over and over again. And you and your partner must be able to truthfully state an identical residential address on the application form for domestic partnership. And neither you or your partner is currently in another domestic partnership or has been registered as a member of another domestic partnership. So the question is, assuming that you want to do this, and we can only do this if it's affordable. I mean, it's, I don't know whether you want to consider putting something in your employee handbook that commits you to do this in case it becomes unaffordable in future years.
I just want to say that I think that we 100% should provide benefits, for a town employee that is in domestic partnership. If they work for the town and they live together with, doesn't matter what sex they are, same-sex couple, male, female. If they're domestic partners and they're in share a residence, and one of the partners is works for the town, and they can, whatever definition that you come up with, they sign a statement. We should definitely provide them benefits.
So Warren, what you're suggesting is that we draft a local law and then we sign it?
Or a resolution by the board,
yeah.
But I'd like to have some flexibility so that it'd be, if it becomes unaffordable in future years, that you're not required to do that. We have to work that out. And I have to work on some language. I'd like to, if we can get something from the insurance company to see what they had. I'm trying to get a copy of the registration form that they use in New York City, but by the next meeting I should have something worked up for you with a resolution for you to consider. And I think it's a very good idea.
Nowadays too, from younger generations, not many younger folks are getting married anymore.
Not in the same numbers that they used to.
I don't know many of my, I know quite a few, but I know a lot of my friends that are in relationships they just don't get married. Or then maybe they're not as religious, or it's not instilled in their culture, and to prevent them from having like medical benefits because they don't get married, I think is wrong, and we shouldn't go down that road.
I don't think the idea was ever here to
I feel
we're not
strong.
trying to do that.
I think there's a consensus that you want to do this. The question is how we formulate.
What the idea was, and why I asked you, Warren, was I wasn't sure what the definition of a domestic partnership was, and how do you qualify or substantiate what is a domestic partnership. The other thing, and this is a minor consideration, it's still a consideration, is that not only is the town paying then for the other half here, so to speak, but also that for each town employee, there is a $2,000 deductible. But what happens is the town pays that deductible for the employees. So it's not a minor consideration. It's something that needs to be taken into consideration.
It would cost, taxpayer dollars, but
I think we all agree. It's something that.
And also considering the fact that in a non-married domestic partnership relationship, it can terminate without a divorce or separation, formal separation agreement. I probably will put something in there about renewing the registration each year about the status.
That's a good idea.
Yes.
Okay. So I should have something for you, but if you could just check with your insurance company, or do you think our agent would have that, or if you get it?
You'll have to check. I don't know.
They told me they don't have anything anymore.
They don't have
They
anything
don't even have the
anymore.
old ones that they use? I mean,
Okay.
Okay, I may be able to find it from someplace else. I don't want to invent the wheel if somebody else has done a better job, but if not, I'll just create something based upon these definitions, and I'll have it for you to review by the next.
I mean, they used to have to provide a lot of financial information showing that they had a joint account, that they both contributed to that account, that, they paid their rent and all the utilities out of that account, stuff like that. That was a lot of the stuff they had to provide.
It will probably be something like that, and to show the financial commitment and interdependence. But they can't file joint tax returns, so we won't have that to show. But I'll come up with something if we can't find a good prototype. The other thing is Militant Gun Club. It's my understanding, George Supervisor had asked me to look into a complaint that you had received regarding the Militant Gun Club dated June 12, 2018, regarding excessive noise and hours of operation. And have we received other complaints, or is this primarily the one that we received?
It's basically been here. There are, I believe that this person speaks for not only himself.
Okay. So this is a very hard issue to deal with, because the gun club, our zoning regulation, supplementary regulations for rod and gun clubs, which I drafted, I can't believe it, back in 1995, and was added to the law. That was the first time we had those regulations for gun clubs. They're quite extensive, and if they were to be applied to a new gun club that was trying to establish itself, you wouldn't have these problems. The problem that you have with this club, if we try to enforce these, is that they're going to argue that they are what we call a non-conforming use, in that they were established prior to 1995, the effective date of the law. There's decisional law in New York which allows you to regulate non-conforming uses, especially ones that result in noise or other noxious consequences to neighboring properties. But they're tough cases to enforce. What we did in in Rhinebeck, and to be honest, I don't know how successful it was. When we passed we updated our comprehensive plan about 10 years ago, we had 2 gun clubs in the town, and there were a lot of complaints about one of the gun clubs. So we did is we established supplementary regulations similar to what we have in Northeast regarding setbacks from roads and screening and hours of operations, but they only applied to new gun clubs. The way we tried to deal with existing gun clubs was to have all gun clubs in existence at the time of the law conduct sound level measurements at the property boundaries. And it's a pretty extensive law with regard to how those sound level measurements are supposed to be taken, and to then come to the town and try to work with the town to try to mitigate those sounds. So what I would like to do tonight, because I don't have any easy answers for you, is give you copies of what we did in Rhinebeck so you can take a look at that and study that. And see if we can possibly come to terms on an amendment to our law which would do something similar to what we did in Rhinebeck. To be honest with you, I don't know how successful that program was, and I have to find out what went on. I haven't had a chance to find out whether it resulted in any mitigation of the noise. But noxious uses, even if they're non-conforming, there is a way to amortize them out. It usually results in litigation. And there are ways of regulating the clubs, which also usually results in litigation. The best way to deal with the issue, if we can have some cooperation, would be to have a meeting with the gun club and possibly with the neighbors. I don't know how you want to do a joint meeting, but for the gun club officials to hear what the complaints are and to find out more about the hours of operation, what type of shooting they're doing, how their operation differs from what it was in 1995. It'd be interesting to know whether since 1995 they've expanded the gun club in any way or expanded their operation or are doing things there that they weren't doing in 1995. If that's the case, there may be some way to regulate that expansion and cut back on that expansion. But if the gun club realizes that it may be that the town has to take some action, that if they voluntarily mitigate these things with setbacks, berms, limiting the hours of operation, limiting the type of weapons that can be used, because some are much more noxious than others, that would be the best solution. So what I think we should do is take a look at this, give it some thought, and maybe reach out to the gun club between now and next month and see if they'd be willing to have a meeting, and maybe the neighbors too, and I don't know whether you'd want to do it at the same time or have one meeting with one group and another with another group. I'm happy to attend the meeting and see if we can broker something. It's not, these are not, you know the process.
It's gonna be a tough one.
It's not an easy one to deal with, and it could be that there's been an expansion of the facility since 1995, which might be in violation of our law, but we don't know because we don't know what existed. We don't have a benchmark as to what existed in 1995 for that facility.
Are non-conforming uses exempt from, for instance, noise laws and so on, so by virtue of being non-conforming?
Not necessarily. We don't have a noise law. We tried to pass one. There was a big outcry over it. Mm-hmm. People came and didn't want it. They didn't want the regulation. So we backed off on that. I still think it would have been a good idea for us to pass that, and we may want to rethink that right now. But yeah, you can probably enforce some of those laws even against a non-conforming use. But it's a very difficult situation. If people want to go to the mat, if the gun club wanted to go to the mat on this, we could be in for a battle. But I would strongly urge you to reconsider the as part of a solution, a noise ordinance. And, maybe we want to take the town board wants to, do a site visit and see what's going on at the gun club during operation. We did that with one of the gun clubs in Rhinebeck, and it was interesting to see how they operated, how much noise was generated. And there was a lot of noise.
But Warren, if we did have a noise ordinance, they wouldn't have to comply anyway, right? Because they're it'd be a non-conforming use.
Well, but it all depends on what noise they were generating in 1995. They're only non-conforming to the extent that they lawfully existed in 1995. It becomes very tricky. Now, what's happened with these clubs, I'm not a member of it, I don't know much about it, but it's been harder and harder for clubs to generate income. So it used to be a local club, local people. They would come, before hunting season and sharpen their skills, and there'd be that type of use of the club. Now they've become a much more recreational and sort of for-profit, even though they're not for-profit, clubs where people are invited from New York and from out of town, and there's much more volume of use. So the noise issue may be a way of dealing with it. And we'd have to find out from the neighbors, to the extent that they know, how things have changed since 1995 in terms of noise.
I want to go on record and say that I would not support a local law establishing a noise ordinance in the town of Northeast. If the town board wanted to go that way, I can at least say I would be a nay vote in that.
Okay. It's up to the board.
Yeah, but I just want to say a few words about gun clubs. So I believe that the Millerton Gun Club is a necessary and needed outlet for sportsmen and gun owners to shoot their weapons. If you don't have a gun club in a town, what happens usually is, folks have guns. We have the Second Amendment in the United States here, and many town Northeast residents are gun owners. I'm a gun owner. I hunt as well. And when you purchase a weapon or a gun, whatever type you may purchase, you usually have a sight for it. You have to you can buy a sight. You have to sight it in. And if you don't have a facility where people can sight their guns in before they go hunt before hunting season, they're going to do it in their backyards, and you're going to have a bunch of bullets, shooting and going off in backyards all across the town of Northeast. If you try to shut down the use of the gun club, and also. How long has the gun club been in operation? When did it start? Many, many years, right? So my other thought is that if you purchased a home near the gun club and are then angry that you hear gunshots, the logic doesn't comply with me. It's like you purchased a home or you decided to choose your residence near a gun club. No one forced you to live there, and if you, I don't support a noise ordinance, and I don't think there's much you can do about noise. Guns. When you fire a weapon, it makes a lot of noise. Obviously, and every gun that is fired at the gun club would need to be legal in New York State, and we currently have one of the arguably the strictest gun control legislation in the country, one of the strictest anyway. So if someone's firing a legal weapon, a gun, at the gun club, I just can't support an ordinance to prevent that. I just want to go on record to say that.
Do you have anything else, Warren?
No, so I thought if you all digest this, and your point is well taken. These are the same arguments we grappled with in Rhinebeck. They're not, as I said, I don't know that there are any solutions to this, except for mostly self-regulation, in terms of being considerate of the neighbors. And that's something that the gun club probably, the bottom line will be, we'll have to try to work something out with the neighbors to see if they can come to some accord. But getting into a regulation is going to be difficult.
Yeah, can I just make a comment? I mean, I think if we can find some outcome without regulation, that's a desirable thing. And if there is some sense that, and I say this as a gun owner as well, and also belong to a gun club, just doesn't happen to be that one, that, a club located in a village or inside a town, to my mind, would want to be a good neighbor as well. Understand their rights to do that, the fact that they've been existing for a very long time. But I would hope that they would want to at least be open to a conversation, let's say, about hours. That's not saying you can't sight in your gun or you can't fire your gun, but it might be that there's a sensitivity to what hours a club might operate.
That would be the best solution.
George, I wonder if we couldn't encourage both the gun club and the adjoining neighbors to get together for a meeting so that they could discuss those issues among themselves. Because actually, it doesn't affect everyone in the town. It affects the residents who are nearest the gun club. And if somehow, it's like a gentleman's agreement, they would understand the problems better than anyone else. And it still isn't going to be easy to come up with a solution, but at least the involved individuals could speak to one another about it, hopefully in a civil way, and maybe come up with some solutions. I don't know.
The only thing that I would say is that that might be a little difficult, especially at the beginning.
I'm sure.
I think you might better bring each in separately, understand what their position is on it. There have already been a couple of meetings with no person between it, and those haven't gone extremely well. Anything else on?
I'll let you digest that. Couple of things on the grants. I did speak to Ann Saylor about the ADA Accessible Grant. It's a little bit more complicated than we had anticipated. She raised some issues with me in a conversation, which leads me to believe that I think we need to have a meeting with the county and the village and the town and the attorneys from the town and the engineer, because she was talking about possibly, instead of one agreement with the town, with the village and the town with an IMA, they're thinking in terms of two separate agreements. The county is, because of the nature of the grant. There's also another issue with regard to utilization of engineering services. You do have, as part of your grant, I think it was $32,000 if I remember correctly, $23,000 for engineering. Normally we would think in terms of having our engineer for the town do that, but she told me that we can't necessarily do that because of the nature of the grant, because they're using federal funds, that it has to go out not to bid in a formal bidding process, but there have to be 3 RFPs, and they want the town to follow, the town and the village to follow the procurement policies of the county, which she sent to me today, which are similar to our procurement policies. So she suggested, and I agree with her, that we try to set up a meeting as soon as possible to discuss this. So I'd like to, it doesn't have to be the full board, but maybe 2 members of the town board, 2 members of the village board, with our town engineer there, and me and the attorney for the village, to see if we can hash out these issues. She is going to send me the standard agreement for the grant with the county, which should come out in a couple of weeks, which I need to review. So maybe the meeting should take place before that or after that, but I'm willing to try to set up the meeting maybe next week. Might be, if we could all get together. So what I'm going to do, if it's okay with you, I'm going to send an email out, and I'll send it to the village, and I'll send it to the village attorney and to our engineer, and then see if we can get some times from the county when probably have them come up here and meet with us and see if we can do this. So everything's going to be great. It's going to work smoothly, but because these are federal funds, it's a little bit more complicated than the usual CDBG grant. We also have to do a certain amount of outreach to firms that encourage minority and women businesses. That's going to be a requirement. She told me that already. So there's a few things we have to straighten out. So I'll take care of that. And
George, just one quick comment about those grants. A previous grant, CDBG grant that the village applied for, and which I worked on when I was part of Townscape, was for a composting toilet to be placed on the rail trail. And I worked very closely with former trustees Steve Waite and Dave Sherman, and the village was awarded that grant. And 4 years later, it is there on the rail trail. It's still wrapped in plastic.
It took 4 years to
but it did.
not good news.
Maybe 3. Certainly was 3. And but it anyway. So Rome wasn't built in a day.
Waiting to use that.
Hopefully we can.
We might keep it wrapped in plastic for a while.
Hopefully we can expedite the process. It's working with Ann is a little bit different than working with the other Christie. Ann has a different view of these things. So I have to do what she tells us we need to do. So hopefully we'll try to work this out. And the one with the village for the storage building, I guess we're waiting to get written confirmation of the exact amount of funds. And then we are going to, the award is pending, even though it's $185,000.
No,
it's not.
No, the 186,000 is actually for the ADA.
ADA. What's the award for the storage? We don't know.
The sum hasn't been decided yet.
So we're waiting for that.
We believe that we're going to get a grant.
Okay. So she said they've told us, and this is in dealing with Christie from the office. Is that the award is pending. Once we find the total amount, then we can move forward with this. And this we can probably do through an IMA with the village and the town. We've already done that pretty much with our memorandum of understanding. So I'll keep in touch with her. So as soon as we get the exact amount, then we can work forward. I'm pretty sure we can work with our town engineer without having to put it out to bid, but I'll find out for sure. And I think that's all I have.
Yep. Okay. Before I move on, I'd like to clarify one issue. Last time Warren was here and we held an attorney-client session, we came back downstairs, went into session, and I was asked during the comment period if I could explain further on some of the what was discussed. And I made a misstatement in saying that we had gone into executive session when we had actually been in attorney-client session. That was a mistake. It was not an executive session, it was an attorney-client session. The entire session was attorney-client. And I'm sorry I made that statement, but that's what happened. Next is, and you have the minutes there from, well, first of all, I guess we got supervisor's report here. And I have a budget adjustment from A Fund. We have an expense increase of $4,985, less an expense decrease of $3,000, less a revenue increase of $1,985. And that is all we have for budget adjustments. And thank you. We have a special abstract dated July 17th, 2018, totaling $7,172.16, broken down as follows. A Fund, $2,589.56. DB Fund, $4,372.45. Payroll TNA, $210.15. Can I have a motion to accept the special abstract?
So moved.
By John Merwin, seconded by
Second.
Ralph Fidelli. All in favor?
Aye.
Aye.
So Ralph's got the ice cream ready.
We have another special abstract dated July 31st, 2018, totaling $545.50, broken down as follows. A Fund, $545.50. Can I have a motion to accept the special abstract? Made by Chris Kennan, seconded by anybody? John Merwin? All in favor?
Aye.
Aye.
I do like your signature, Chris.
No, it's just, Christopher was way too long to write out.
And we have an abstract dated August 9th, 2018, totaling $64,060.48, broken down as follows. A Fund, $40,118.14. B Fund, $3,028.61. DB Fund, $20,913.73. Can I have a motion to accept the abstract?
So moved.
Made by Ralph Fidelli, seconded by John Midwood. All in favor?
Aye.
Aye. I believe you all have copies of the special town board meeting, July 25th. Do we have any comments, corrections, anything?
Trying to find, no, I made one. It's a
Minor grammar.
25th, this, wait, here it is, here it is. Hold on. Nothing on the 25th. I have something on the 9th.
Can I have a motion to accept the minutes?
So moved.
Made by Ralph Fidelli, seconded by
Second.
John Midwood. All in favor?
Aye.
Aye. Next is the town board workshop minutes of June 21st. Anyone have any comments, corrections?
Yes, I had something on the last page. The only comment the CAC had was that they land used, and I think they meant that the land used, right? The, change the they to the, otherwise it's okay.
Make a motion to adopt the minutes with Ralph's.
Yeah, I have a couple of minor things here that you can just take a look at, and they're really minor, so. With those corrections, can I have a motion to adopt the minutes? John Midwood made the motion, and Chris Kennan, second. All in favor?
Aye.
Aye. Okay. General comment period.
Wait, do we have the voucher committee for next month?
The voucher committee for next month is John Midwood and Ralph Fidelli. I'm sure you didn't want to be forgotten. No.
Yeah, Joan Arneson, for the purposes of this. One of the things that I have not seen during the period that I've attended board meetings, and maybe I've missed something, is a periodic report on litigation to which the town is subject. And it seems to me that it would be appropriate to periodically simply give a report as to what actions are pending, names of parties, date filed, what are they for, what are the actions for, if they seek damages against the town, is there insurance, and where does the litigation stand in terms of, have the pleadings been closed, is it in disclosure or discovery, and so on. Obviously, litigation, both because of the expense of the process and because of the possible outcomes, can affect the taxpayers, and none of the information which I have just listed is privileged. That is, none of it would impinge on the attorney-client privilege, and I just think it would be an important thing for the town board to periodically advise the members of the town about.
If I can comment on it, I do give reports on litigation. I do that all the time. We first of all, we go in executive session to discuss pending litigation so I can advise the board on the pending litigation. Then we come to the town board meetings and we do announce what disposition of cases. So we have done that over the past. It just so happens that we don't have any pending litigation.
Well, that's wonderful.
Everything that we've had has been resolved in favor of the town. So there really isn't any pending. But when we do have it, I do both report to the board, and to the extent that I could discuss it in open session, I also discuss it. Hopefully we won't have. The only other thing we have are tax certiorieries, and I do not handle the tax certiorieries. So that's something that would have to be the council that our assessor uses.
Those are a matter of public record too.
Those are a matter of public record,
Yeah.
so that's, but I don't handle those, so I can't give those.
But the town board could report that if there are, what tax certiorari is pending.
Yes, absolutely, yeah.
I think it'd be a good
Yeah.
policy to say like once every quarterly, once every 3 board meetings, just, give a brief, kind of this, brief review of the
I have
cases.
no problem with
I
that.
have, I have no problem, but
I
it
believe
just so
we have-
happens things
And
are
if there is none, it'll
Things
be a
are
very
quiet,
quick
thank
report.
God.
I believe there's one tax cert case which supposedly has been settled, except that we haven't
We haven't heard.
received any final dispensation on it, so. And we have one other that is currently pending, so. But the names and stuff I will have to check on, and I'll have to check on what's
Thank you.
going on with that.
Chris Regan.
Yes.
I'd like to add my voice to the concern about the open meetings law and the compliance of the board with it. And you guys probably understand it better than I do, but I do wonder if the client-attorney meeting really fits within a town board meeting at all, if it's not actually under an executive session, correct? Is that there's nothing within the open meetings law that refers to any other way to close the meeting to the public, is there? Other than executive session, and it's specific, given very specific reasons for it. So I'm curious if just saying that you're meeting with the lawyer during a meeting is actually kosher with the law.
If you want, I knew that there was some issue with this, so I brought a committee on open government, because it is hard to understand the difference between executive session and attorney-client session. They're two different animals. The attorney-client session is an exception from the open meetings law. There's a privilege that the town board has, or any board has, to meet with its attorney to get legal advice.
It's a reason to go into executive session.
Well, can I finish?
I thought you finished that point.
I was going to respond to you. Okay.
And I just wanted to ask if it's named within the law as, in other words, is a session with your lawyer named at all within the statute?
Yeah, do you want me to explain?
I'd love you to answer that question.
Okay, but I will if you give me a chance, okay? Thank you. So an attorney-client session is, you can have it during the meeting. Technically what you do is you, instead of going into executive session, you adjourn the meeting and then have an attorney-client meeting and then come back into session, or you can have an attorney-client meeting outside the scope of a meeting. You can have it before or after or on another day. An executive session is something that happens during the scope of the meeting. So I just wanted to explain the Committee on Open Government, how it describes it. So with respect to the application of terminology, this is Robert Friedman, who's the head of the Committee on Open Government. I point out there are two vehicles that may authorize a public body to discuss public business in private. One involves entry into an executive session. As you are aware, and as indicated in the response to Mr. Boyan, that was the complaint, of the open meetings law defines the phrase executive session to mean a portion of an open meeting during which the public may be excluded. And the law requires that a procedure be accomplished during an open meeting before a public body may enter into executive session. In short, prior to conducting an executive session, a motion must be made that includes reference to the subject or subjects to be discussed, and it must be carried by a majority vote of the board. The other vehicle for excluding the public from a meeting involves exemptions. Section 108 of the Open Meetings Law contains 3 exemptions. When an exemption applies, the open meeting law does not, and the requirements that would operate with respect to executive sessions are not in effect. Stated differently, to discuss a matter exempted from the open meetings law, a public body need not follow the procedure imposed by Section 105.1 that relates to entry into executive session. Further, although executive sessions may be held only for particular purposes, there is no such limitation that relates to the matters that are exempt from the coverage of the open meetings law. Relevant to Section 108.3, which exempts from the open meetings law any matter made confidential by federal or state law. When an attorney-client relationship has been invoked, it is considered confidential under Section 4503 of the Civil Practice Law or rules. Therefore, if an attorney and client establish a privileged relationship, such communications are exempt. So there is nothing, the way to handle attorney-client meetings as opposed to executive sessions, which only occur during a meeting, would be, again, if we want to go into an attorney-client meeting, we should probably be more careful about actually adjourning the meeting or having it before the meeting or after the meeting. Or you can have it on another day. You can have it on a Wednesday if you want to meet. And I meet with many of my boards at different times. But there's no prohibition, there's no problem with having it during the course of the meeting. Now, I understand that it is sometimes not fair to the public to halt the meeting for purposes of doing that, and we're trying to discuss ways of handling those meetings or sessions with me either before or after the meeting, so it doesn't unduly disrupt the meeting.
Wouldn't it have to be during a board meeting because you have to publicly enter into the executive session? So what I would recommend, and I've always thought this would be a better way of doing this, is that you go through the entire agenda, general comment period, then executive session, and then we simply come back and adjourn the meeting. So the public doesn't have to sit there for 30 minutes while we meet with our council and then make their comments. Because people a lot of times, I mean, unless you follow town government and you're here every month, people generally come because they want to do a general comment. And to make them sit there for like an extra 45 minutes and then come back, it's cumbersome. I wouldn't do it that way. I would, I mean, it's up to the board or whatever, and adopting, or I guess to mainly George and drafting the agenda and accepting the agenda, but a recommendation would be to just move executive session to after the general comment period. So then we can just simply come back in a session and adjourn. People can make their comments and then they don't have to sit there for a half hour. I don't know.
Wouldn't it be better though to put it at the beginning? In other words, before the meeting, say a half hour before the meeting. There may be something within the agenda that, that meeting may be, have reference to.
The issue with that is you have to be in session because sometimes this, for executive session, for example, there could be a vote where three board members vote nay, and we're not allowed to enter executive session. So it has to be in the official after 7 p.m. You could say start the meeting at, it wouldn't make sense that way. I mean,
Can I follow up on, I don't feel like I've really gotten my point across or understand necessarily what the board is thinking in terms of the open meeting law. Let's say tonight's session was an example of a typical meeting in which you typically would have met the attorney and had the discussion you had with him in private. Is that true? Is that correct? Would that have been more typical?
No, not for this type of discussion. No.
The way the law is spelled out, it seems determined to do one thing, and that is present the public with exposure to almost all the decision-making that the board is doing as a group. So it gives specific reasons why you would want to meet in private, but they're very specific, and I can't believe they come up every week or every month. So at that point, it seems any effort to be talking with your counsel or together in private is counter to what this law is trying to achieve. Now, I make no assumptions on nefarious efforts, but the point is the law is there for a reason, and it's to encourage the public to see what's going on, to understand what's going on. And if you can explain to me why, other than those reasons, or again, some litigation that your counsel is counseling you about, why, what's the need for not having it in open public? I'd like an answer. I'd like some feedback on that.
I'll weigh in here. The town board is lit, and the town board needs to have executive session to discuss litigation, and we only meet once a month. We have 12 meetings in a calendar year, and usually there's ongoing court cases, and we meet, and it does take a while because.
That's fine, as long as it falls within the.
Can I explain?
Things.
Sorry, can I finish? So, none of the 5 board members here have a JD, unless I don't think so, right?
I don't think so.
So none of us are lawyers. and you make decisions. You run for the town board or town supervisor, whatever you want to run for. All you do is, let me rephrase that. So when you run for office for the town council seat, you simply win by getting the most votes. Then you come in and you have 1 weekend of training. And then you have to, you assume office in the January meeting. And you have to make a lot of complex decisions that involve a lot of money for the taxpayers. And you need to meet with legal counsel because you're making complex decisions that involve a lot of money, and you're being sued in some cases. Like the town board, you either you're initiating litigation. You're either the defendant or you're the plaintiff in litigation, and you only meet 12 times a year. And there's a lot of times like multiple. The reason why we didn't have an attorney-client session now is there was no like tax certiorari. I'm mispronouncing, but tax cert cases come up very frequently, and the assessor, it's a very common thing, and you only meet 12 times a year, and you have like sometimes 4 or 5 of these cases, and you gotta, as a board, come up with a decision, or not a decision, but you at least need to understand what the law is that you're ruling on, and you need a lawyer to do that.
Yeah, I'm certainly not objecting to anything that falls within the parameters that the law, the open meeting law spells out. I'm not objecting to that. I'm claiming ignorance about how busy you guys are with litigation or employee matters or all of the exemptions that are given. I'm just stating that I would hope you consider, if those aren't the reasons for going into an executive session or into a private meeting with a lawyer to talk about town business, that you keep in mind the open meeting law is there just for that reason, to discourage that.
Right. And I want to note too that I personally, I 100% believe in government transparency. In these video cameras, that's basically I've worked for a couple of years to finally get this up and running. And I believe in transparency, but I also believe I know that we have the legal right to do so as a town board, and I believe it's necessary to meet with a lawyer because we have to rule just make a decision as a board in litigation, and we're not lawyers. We need legal advice.
And again, that makes perfect sense within the exemptions listed in the open meeting law. Like this evening's discussion was interesting, and our lawyer here played a big role in it, which is all fine and good because we could see it. I guess what some people are nervous about in the community is that if, again, business outside of litigation is being discussed, as he was discussing with you, laws, et cetera, all kinds of things. Those things should be discussed, even with the lawyer, in open meeting, I think.
No, I'm sorry, you're absolutely wrong on that. The purpose of the attorney-client meeting is to discuss, to answer questions, and for the board to get legal advice. It doesn't apply just to litigation, it applies to any legal matter.
Why aren't you talking to him?
Because
it's okay, I can hear it.
If I can talk without being
Some
interrupted.
folks just talk to the board, and some folks look at the camera or the.
Why what?
I mean, it's just a personal preference.
What's the question?
I don't know. The question was, why aren't you looking at him?
Because I have a stiff neck, I can only move my neck this way.
As long as the
Sorry,
voice
I
is
can't, I
heard.
can only move this way.
I'm sorry.
So the purpose of the attorney-client session is to get legal advice from the board. No decisions are made, there's no deliberation. Anytime we meet in an attorney-client session, we come out in the public, and if then the issue is debated or you make decisions. The purpose of an executive session is different. It's to discuss certain matters which are prescribed and allowed to be discussed, such as specific personnel matters and litigation. Those we do in executive session. Then there's the open session where I come pretty much to every meeting and give you an update and discuss with you legal matters in public. I mean, there's very few times that it's not on the agenda that I discuss legal matters and give you advice in the public. Those are the three ways we communicate. The only thing that I can offer is that I would agree that if we're going to do an attorney-client session, it's probably best to do it after the meeting so it's not disruptive. But an executive session is usually done during the term of the meeting. It has to be done during the term of the meeting. And you can put that at the end. There might be times, though, that you need to get attorney-client advice or do an executive session, try to turn as best I can before the meeting. Because
before the meeting.
no, but you would want to do the executive session at the onset of the meeting rather than at the end of the meeting. But the attorney-client session can be done at any time.
Right.
And we're pretty careful about making sure that it's limited to getting legal advice, for me to give you legal opinion and input on a whole variety of matters. There's a lot of issues that not just litigation, that require my input, as you can see from tonight. I have no problem putting out at the end of the meeting for the attorney-client so people don't sit around and wait for them.
Is it, I'm just got a question, I'm not sure, like, would you prefer because we can do attorney-client sessions outside of the board meeting, correct?
Okay.
Would you prefer if we don't do that, just like meet with our lawyer? No, I'm just asking the public.
Oh.
Would you prefer if we don't do it so you don't have to sit there?
I think that
Excuse me, I think if this is a procedural thing, you were told when I was in government, if two or more people meet together, what is that called? What is it?
If two or more
Two
people?
or more board members meet together or discuss an issue relative to government, what is it?
If three or more means
Two board members.
Two board members.
Three or more.
It's a meeting.
Three or
It's
more.
a meeting, that's what I'm trying to get to, this is a meeting. So in order to have a meeting that's legal, you must convene a session. I don't think if you're going to have an executive session outside of the body of the meeting, you're going to have to convene and stating that we've convened this meeting. And it should be embedded in the body. I think
It is in New York State law. Executive sessions are legal.
I'm not saying they're not legal, I'm just saying it looks bad. It looks very bad if you have an executive, this is what he's trying to say, an executive session outside of a meeting.
We can have an executive session.
But like,
So let me just,
Sorry.
we never have executive sessions outside of a meeting.
And
It's
you're
always
deciding,
been,
you're deciding where this should be.
you're mixing it up with an attorney-client
No,
session.
I know exactly,
Yeah,
because this has
okay.
been oscillating back and forth. I listened to what you said about organizing the meeting so that people don't have to sit through the entire meeting and listen to everything that's going on and move on. If they don't want to, I like it.
Is that, do you like that?
I don't mind, I learn something all the time. I have no life. But anyway, what I'm saying is that I think that if I'm not mistaken, once you have a meeting and it's adjourned, that's it. You can't reconvene that meeting. Is that not correct?
You can reconvene.
I was told you couldn't reconvene. The Board of
I don't know if
Education
they tell you
said
that,
don't
but
close
you
the
can adjourn a
meeting.
meeting
You
and
can't
then come back
reconvene the
and
meeting.
and
Close the
reconvene.
meeting, but
Yeah.
you can go off into
You adjourn the
executive
meeting.
session, come back.
Right, you can do that, but once the meeting is over, the public, it's not really open to the public anymore. Once the meeting's adjourned, is that not correct?
Correct. If you were to have an attorney-client meeting, not an executive session,
I'm talking about an executive
you
session.
cannot adjourn, it has to be done in the context of the meeting. You don't
Okay.
adjourn the meeting, you go into executive session,
And then you come back and
and then you come back and do your
you can
business.
do that in the middle of a meeting.
Correct. Or at
And
the
what was
beginning of
your
the meeting or at the
preference-
end.
What was your preference that we do, Mr.?
My preference is that, like, for example, does anyone have a copy of this agenda? You know, call to order, well, I'm not gonna go through all of them, but we do everything we did. We approve our minutes, general comment, so anyone can say what all they want to have to say, everything they have to say. We'll answer all your questions, general comment. Then people can leave if they want to. I mean, if you want to sit here the whole time, but general comment, and after general comment, we have to be during this official board meeting to enter into an executive session. And then we do our 30-minute, whatever it may be, executive session. we will then come back to the town, to the table here. We have to reconvene the session and simply make a motion to adjourn. And once there's a vote to adjourn, then we leave. But you guys won't have to, the town, the public, wouldn't have to sit there for 20 minutes and wait, and that's what I.
John, we're not concerned about having to sit and wait for 20 minutes. That's not the issue. The issue is that ever since I've been coming to these meetings, on the agenda, for me, this is the issue, I'm not speaking for anyone else, is, on the agenda is executive session.
Yeah.
Every agenda has it on. I have here from 4 different towns, there's not one executive session in their agenda. But every time I come, there's executive session. You guys go into it, you do not tell us, by law, you're supposed to tell us something about the executive session, but you don't. And I'm not saying there's nefarious stuff going on, but the people need to know what the executive, that you're holding all these executive sessions, many, at least once a month. We need to know something about that. It's not that we have to wait, and sit here while you go. It's not about that.
You want, can I respond to that? Like, my personal opinion as a town councilman, I agree with you that there should be a little bit more information. I mean, as much, more information given to tell folks what we're going in executive session. I agree. It's not my role to kind of explain that. But I do agree with you. I think we could and we should say more, provide more information before we go into the executive session as to what it is pertaining to. I agree with you.
And what happened tonight was, to me, quite interesting, with Warren talking about things that may have gone into executive session if it was not tonight.
No, those issues would not have been discussed in executive session.
Those wouldn't have gone into it.
Those might have been discussed in an attorney-client
Well,
session.
most of the executive session, I mean, I can't talk about executive session, but what most of there's a lot of times it's tax certiorari cases. Like, I think it would be helpful if you, maybe Warren, can you just explain quickly what a tax cert case is?
A tax certiorari is a proceeding brought under Article 7 of the Real Property Actions and Proceedings Law by a property owner who wants to challenge their taxes. So after they grieve their taxes at grievance day, their remedy, if they are not satisfied with the grievance, is to file either a tax certiorari proceeding, which is a special proceeding in Supreme Court, or they can file a small claims if it's for a residential piece of property. And the issue there is whether the court should reduce the assessment. They're complicated cases.
So
But let me ask you a question. It sounds to me as though, to some degree, perhaps the agenda is misdescribing what the sessions are.
It could, that's possibly the confusion. I think that we have to be more careful about describing what is when we go into executive session, that it is in fact an executive session as opposed to an attorney-client session.
Precisely. And let me make one further point, which is one of the issues about the attorney-client sessions that the board has to be very careful about is waiver of the attorney-client privilege.
That's correct.
Which you can waive the privilege by disclosing information or communications with your lawyer or whatever, and that can have very serious adverse impact on litigation, for example. So it is highly appropriate that matters which are truly subject to the attorney-client privilege be discussed in separate sessions with the board only.
As a matter of fact, when you go into an attorney-client session or have an attorney-client session, nobody else is permitted to be present, because that destroys the confidentiality. In an executive session, though, we often bring people in who are related. You might have the engineer on a certain case, if it has to do with litigation or has to do with something that we can legally discuss in executive session. I think the important thing is there needs to be more clarity as to what we're doing, and I think I have no problem with shoving the attorney-client session, if we're going to do that, to the end of the meeting. I think that's a good idea, but on the occasions where we have to meet before the meeting, we have to do that in order to address something that's going to come up before.
John pointed out none of us are attorneys, so I'm part of that group. Why is it that under conduct of executive sessions, Article 105, that item number 4 is discussions regarding proposed, pending, or current litigation? Would that be an executive session of the board without an attorney, where they just want to or need to discuss?
No, that would be with an attorney, yeah.
Okay,
Yeah.
because that is under executive session.
Yeah, that you can do in executive session,
Okay.
pending litigation.
Yeah.
But you may have a session, but you may want to, there may not be pending litigation. There may be a legal issue that you want to discuss, an easement issue that you might want to require, and you need some legal advice on that, but we can't discuss that in public. But it's not subject to the exemption for an executive session. So you can get your advice in an attorney-client session. It's hard to understand the differences, but there are.
But, yeah, so in order to go into executive session, you have to meet certain criteria.
Correct.
Okay, so would it be possible, if you know you're going to go into executive session, on the agenda, say, we're going into executive session, here's the criteria we have met to go do that? Would that work?
What do you mean the criteria?
Well, certain criteria has to be met to go into executive session. So you know before you're going into executive session, you've met that criteria.
Well, all you do is state we're discussing pending litigation, or we'll say the name of the case sometimes. Yeah. Right. Well, I think we do that.
It just says.
Well, but we do that when we go into executive session. We need an executive session.
If I'm just saying, if there are people who are concerned, okay, why are you going into it? You know, what you discuss, or how much, information can you give us? Maybe just have it in the agenda.
Given out on that. We'll have to find
There's
out.
not much more information that we can give you, because the item that you discuss in executive session is just supposed to be described in very general terms.
About what information can be given out. That doesn't bother-
Written in the, rather than just generic language. Sorry,
Bill comment? Bill, have you recognized? Thank you.
Yes.
So I've found this to be really, really interesting. Not just the public comment session, but the whole meeting, because this has been a very different kind of meeting than the ones that I've been attending for the last year or so. So first of all, my comments and questions are addressed to the board. And of course, Warren, if I say anything that's factually incorrect, please correct me. Well, a lot of us turned out today because I think we were concerned about the fact that, I'll say since February, there hasn't been a regular meeting of the Town of Northeast Board that hasn't included either executive session or attorney-client session. So today we showed up, and I was happy to see that George had said that will not be part of the meeting today. And I think that this meeting feels to me like the way to hold a meeting, because the discussions were held in open, in public, and we all got to hear what transpired. The different points that were made, who would support what, all of those things give me a feeling of knowing what's going on in my government, which is very different from a meeting where, and pardon me for this, George, but, like we go through the special abstracts and, nobody has any idea what we're talking about. I really appreciate the reports from committees, but, making the actual decisions in public, I think that's the key to a democratic board. So my comments and questions basically are, is this a change in policy? From hearing the public comment and the response of the board, I'm guessing not. And while I very much respect the board's need and right to enter into executive session to discuss sensitive matters, the ones that are specifically listed in the Opens Meeting Law. I don't think the board has done a very good job in the past, I'm not talking about the attorney, I'm talking about the board, in explaining in a way that doesn't compromise the privacy, the necessary confidentiality of what's being discussed. I think that the intent of the Open Meetings Law, at least as I read it, is if you go into executive session, a motion is made, and there's a lot of stuff in the Committee for Open Government about sufficiency of motion. But I think you guys need to go above and beyond that and basically try to tell us, okay, we're going to go into executive session. We're going to discuss free tax cases. Fine, please tell us that. Or we're going to go into executive session. We're going to discuss a matter under current litigation. In that case, it's public record, right? So you can tell us, this is a case in New York State Supreme Court, case number so-and-so, we're going off to discuss it. Not telling us anything that's going to compromise confidentiality. It's all open. But the problem has been that even after I ask at the end of meetings, what did you guys discuss? It's always very vague. It's, and that's, and that vagary is what time and time again is mentioned in the opinions issued by the Committee on Open Government. You have to say at least something about why you're going to go into executive session. And I would ask that you please do it in as specific a manner as possible without compromising confidentiality. So that's really the crux of my comments. I don't know if policy has changed. Are we going to see more meetings like this in the future, or are we still going to jump? I'm sorry. Well, I can't give you the floor because it's not my job, so.
No, just so everyone knows, what I was talking with George about, asking him earlier, was what I thought would help is rather than, because George puts together the agenda for the most part. We discuss everything when we have additions, but rather than saying like just a generic language, like meeting with council, generally matter of executive session if necessary, to specifically type in the agenda, meeting with council for XYZ, like provide some data on the litigation, and then if you would you be willing to do that?
That's fine. I don't really have a problem with that. I don't think, Warren.
It depends on what we're going in for. I mean, there are issues.
Depend on how much information we
that
can really.
When I go in executive session, there are issues that I would describe as at least quasi litigation that I would rather not provide any specificity before going into executive session.
So let's leave it that
there really is a confidentiality.
Where we can specify, be more specific.
Threatened litigation, we can't.
Clarification of a term, I'm so sorry, but what is quasi litigation? Sorry, so I can.
Litigation is a lawsuit.
Quasi-litigation is something that's sort of like a lawsuit, but not really a
Can I
lawsuit.
like break down?
An administrative proceeding, an administrative proceeding.
That's litigation? That's
I would,
litigation?
if certain certain administrative proceedings may involve employees, and we cannot discuss more information in the
That's
public
not
session.
litigation, that's an
But
employee
for the
issue.
litigation, what I think we should do is that if it is on a docket, a public record, put down the docket number on like meeting with council regarding docket number. If you're interested in it, look it up in the docket. You can read the public documents and know what that case is about.
This is A through G. You certainly could put one of these reasons down. That's what the law says you go into executive session for. So you certainly could put that with maybe a little bit of detail. A through G, matters which will imperil the public safety if disclosed. There's a the law says these are the reasons you go into executive session, and certainly one of these reasons could be put down, maybe with a little bit of detail.
And then the name, the number, I like the docket number.
Yeah.
Mr. Woodward's idea very much. Put it down, if it's already a public matter.
It's public record, you-
Then
it's
give us
public record.
which
You can put it-
matter it is. Great.
Meeting, I mean,
And then the,
meeting with litigation regarding the docket number, and it's searchable, you can search it on a legal database.
I have no problem
If I
doing
could
that
just-
if it's a matter of public record.
If I could just make one more comment, and that is that I hope that the board is taking seriously the, the desires of the people that made that law in the state. And what I'm saying is that obviously the executive session has specific things that you meet for, and otherwise you don't. And it seems to me what happened tonight was the lawyer was able to converse with you, played a very large role in the discussion tonight. And I'm guessing, but I'm assuming a lot of that happens when you meet with him. And I guess the purpose of the law is to avoid that. The purpose of the law is to have you guys doing your decision-making in public. So even though he's the only lawyer, it doesn't mean he can't be present as he was tonight, talking to you about a given law or a given idea. And I would assume that if you were following the gist of the law, you wouldn't go into a private session with him unless it was specifically for something that the rest of the public couldn't hear. Obviously, tonight that didn't happen. And I guess I'm just trying to get you guys to affirm that you agree with the open meetings law and its purpose. That's all.
We do, we do. Like, for example.
You don't have to agree, it applies.
We can't.
Well,
We don't.
Excuse me, I just want to comment on that comment. You said you basically have a way out. You said that you can have these guys meet you in private anytime you want by just.
Let me finish.
Well, I'm just referring to his statement. He
So-
did say it, I did get to respond.
Okay.
It doesn't apply to you, is what you told me.
Part of the open meeting law, which we take very seriously, is that we can't, 3 of us, of the 5 members of the board, if it can never be 3 of us that can meet and discuss town policy, and that anywhere. Like, we can't even go to get a beer together and talk about town policy. 2 of us can.
I understand.
But it has to be like 2. We can never get 3 of us together and discuss town policy, or else it's a public meeting. So a lot of times it's like 2 people are meeting, and then another 2 people meet, and then 2 people have a phone call. It's just the way we operate, and we never get, unless one of these board meetings, once per month, or in an executive session, which we do need. And we're not going to not do executive session. We do need to do that, but that's the one time per month that the 5 board members here are discussing town policy. It happens 12 times per year.
Yeah, but I'm still not clear that you understand what the open law, the open meeting law refers to. It's basically saying you should do that in public. It's basically saying you should do that in public. That's what the law says. And the only way out of that is, according to the laws I understand it, is executive session. But that's only for certain things. It's not just to talk about stuff. To talk about stuff.
You're right, and we don't do that.
Okay.
I spoke a lot this board meeting. I think I need to let other board members talk. I mean, Ralph, you want to?
And also, I'm still standing here.
This is a very delicate problem, and it amounts to trust. I personally need the attorney-client session because I'm not a lawyer. And very often we handle issues that require legal counsel. We get some input from that. What I happen to agree with all of you is that the attorney-client session should always be open. That's my personal feeling. It should not be a separate meeting that's out of the board meeting. Because then everyone could say something is going on and we don't know about it. I mean, that's just my own personal feeling about this, is that I think that's some of the things that are going wrong right now in governance in general, is people do not trust government. And we have to get to the point where we really do trust the people who are representing the town. I feel that it's important for this attorney-client session because what we always say is we can not have a meeting with more than two. So the only time that all of us can get together as a group is in the meeting, the town meeting. And at that point, we always discuss legal matters. And we need to have the lawyer there. We need the give and take, the conversation, so that we can form an intelligent decision. We have to individually have to make decisions. We want to make intelligent decisions that are based on law. So that's just my own personal feeling.
Just let me give you a caveat on that. I mean, there are times that I need to be able to give you legal advice that then doesn't come under the umbrella of an executive session where I cannot give you that legal advice in public. So there has to be as with any attorney-client relationship, there has to be a confidentiality aspect, and that's what an attorney-client session is for. But the attorney-client session is not to conduct business in the sense that you don't make decisions during that. You don't deliberate and make decisions. That has to be done in open session. And there are certain things that I can discuss with you that are in the nature of legal advice, which I can do in open session, which won't impair the legal rights of the town. But there are some things I cannot do that. So I have to have that ability, as all municipal lawyers have that with their
Could you give an
with
example
their
of that
clients.
so we can understand better what those circumstances might be?
I couldn't hear.
She asked for an example of what could be discussed under attorney-client session. I think, a hypothetical example.
Where you would have to go into private.
Yeah, if we
It
were
doesn't
discussed
fall
that we
under-
had to, the potential for acquiring an easement, to expand a road, for example, and the board wanted to know what the laws were with regard to acquiring that easement with regard to that particular case, that's something I would give to them in attorney-client session, because if it was discussed in public, then it impairs our ability to then enforce the easement, take a legal action with regard to easement. That would be an example of something like that. But people talk to their attorneys all the time. And again, I go back to Mr. Freeman. Insofar as the board seeks legal advice from its attorney and the attorney renders legal advice, I believe that the attorney-client privilege may be validly asserted and the communications made within the scope of the privilege would be outside the coverage of the open meetings law. That's what the attorney-client privilege is. The town has the right to an attorney-client privilege, just as you would if you were hiring a lawyer to render legal advice to you. I don't think you'd want to have that in public.
I just want to, I'm confused. I think you said we could meet on a Wednesday. I do
Yes,
it
we
all the
could.
time. And that is true that as attorney-client privilege, you could meet and it wouldn't have to be.
It can meet
The
anytime.
public wouldn't
Yeah.
need to know about it. It would
That's-
never have to be, even though
that's
there's
correct.
more than two people.
No, I could meet with the entire board in an attorney-client session outside, as long as it is an attorney-client session and the board is not deliberating or taking any action during that meeting.
And it seems, okay, so it doesn't seem odd that the 8.
But we don't do that. I mean, that's a rare
But there are
case.
8 ways that you can meet, and the open law meetings, there's a spirit and the.
I'm sorry, I'm having trouble with
Just, it's.
Okay, if you could
kind
come
of-
closer, I could hear you better. I
It's
just
okay,
can't.
go ahead.
Okay.
What might be helpful too, and I need some legal clarification on this, Warren, is the laws regarding caucus.
That's different.
I need to know,
If the members of the board are all the same party, what did it, I just want to correct something you said about getting together and having a drink and discussing the town or something. You can do that. What you can't do is get together 3 members and conduct business. It's the conduct of business. Doesn't mean that you can't meet together and discuss something that's going on in town. It's the conduct of business. But if there is an exception to the law for political caucuses, and if you're all members of the same, if you're all Democrats or all Republican, you can caucus and actually conduct business conduct town business during a caucus.
So,
It's
explain that a
really
little
something
bit
I
more.
can't, I can't justify it, but that's what the
Does
law
that
is.
have to be a published, open?
No, it's
So for-
private.
I mean, it's pretty, so for example, you know, I don't know.
You 3 could get
So
together.
Chris,
and-
Chris,
I
Ralph,
think it
and
has to be the entire board, if I'm not mistaken, but it could be that, no, 3 members of a board, if you have 3 Democrats and 2 Republicans, 3 Democrats cannot get together and caucus and do town business. If you have 5 Democrats or 5 Republicans on the board, it's my understanding of the law that you can caucus and conduct town business.
So
Bizarre, but that's the
I just
case.
like, my question is,
confusing.
my question is,
I think it's terrible. I don't agree with that law.
like, in the county legislature, Dutch County legislature, there's caucuses where the Democrats get together.
And the
Probably, I'm not trying to get all political here,
Yeah.
but my question is, can Chris, Ralph, and I have discussed town business, the 3 of us, together in private?
I don't think so. I don't think the same caucus privilege that the county legislature has applies to a board where the board is not all of one party. But I can check on
I mean,
that.
kind of about saying, I haven't been doing this, I heard of caucusing I just like.
Yeah, it's
thought
done
about
all
it.
the time. It's
And,
done all the time. But I don't know that it applies to town boards, but I can check on that. But I don't think 3 members of a town board who are Democrats or 3 are Republicans can conduct town business. But the caucus law is probably different for county government because you have how many members?
Yeah, quite a few.
So George, I had 4
Bill-
points, I
Bill's
got
trying to
through
get some
3.
stuff
So I'm
in.
gonna try- Okay, all right, so the points, okay, this is the first regular meeting in recorded history in my mind that, the first public meeting where we haven't gone into executive session or attorney-client privilege. Great, thank you very much, because I think it made the meeting a much better meeting. And with respect to the question about policy, what is the policy? I heard a good discussion about what the policy is, and I think that it would be great if at some point there could become a more formal policy about how the board enters into either executive session or attorney-client session so that it feels like it's being done with a little bit more gravitas. The sufficiency of motion issue, that's been a real problem in the past and hopefully will be addressed. The final thing that I wanted to talk about was attorney-client session, and there was some good discussion here which sort of sets me up for that, which is to say that I personally don't, and I hope that nobody else here begrudges the board the right to speak privately with their attorney and to have that in confidentiality, because that is the foundation of our legal system. However, that is an extremely powerful tool. You have to recognize that. And you have to think very carefully when you're doing that whether you need to do it, because it seems to me that almost everything that you could discuss with your attorney could be handled either in open session like today. Warren said, hey, we could have discussed all of this stuff in attorney-client session, but we didn't. It was fine, and there was no need for it. If it fits in the open meetings law categories for executive session, I would say please find that category and say we are going to discuss a matter regarding the medical history of a particular person, for example, a particular employee. That's not necessary to go into attorney-client session to do it because you have this tool. So the hierarchy should be completely open meeting, executive session properly handled, and only when it's absolutely necessary, go into attorney-client session. And I would say, please use that tool very, very carefully and try to, when you're going to do that, try to explain to the public in some way that doesn't compromise the confidentiality what it is that requires you to do that. And that's the end of my comments, and I very much appreciate it.
Are there any other comments?
Yes, on the content of your meeting, I have 2 questions. One with the possible, looks like a shared service with emergency services for now, the 2 or 3 other municipalities. My concern with that is, in the future, if we grow bigger and require a bigger merger, will that in some way really substantially raise the price, what we're trying to avoid with medical services?
That's what the study
I'm just concerned
is.
that if we say, okay, it's a county thing now, and we're gonna, like usual, feed into the county bucket, and what are we gonna get out of this? That's not something I want.
So, I'm trying to answer your question without taking 20 minutes to do so, but in order to, when your question, you were referring to the 4-town study that I was talking about?
Right.
So that study is the goal of that study. Like your concern is it's going to cost more.
It's gonna cost more.
So the goal of that study is to make it cost less. And if it doesn't cost less, I personally wouldn't vote in favor of doing it.
So by being with this merge effort in the front, if it doesn't benefit our community, do we have the ability to pull out of it?
Yes.
Yes, the town board would have to approve, to vote, a majority of the town board would have to vote to enter into this agreement. And if we vote, and we can vote no.
And my other thing is the assurance, because I understand how EMS works. We do this merger of services with these other communities. Are they going to have one ACLS ambulance for the 3 communities? Or are we going to, because they have to meet that 15-minute goal, and I don't want to see that.
To be determined.
That's a critical issue, I think, and that, to be honest with you, that has come up in these meetings of, we can save money by not having paramedics on every call. And I personally don't agree with that and would not vote to support anything that didn't require a paramedic at every call. I mean, it kind of touches a little close to home. I literally, Sunday, was in a, car accident, and I needed a paramedic because my, blood pressure was spiking. And, I think
You don't have that as an option here. It's not an option for us. So I think it's something else that's an alarm for the community block grant. I think every person in this room is a potential candidate to use an AED on, for one reason, our age. And I am very afraid, and I keep asking somebody at any level of government, town or village, we need to have these in strategic places in this village. And we're foolish. I can use an AED, I can save your life. It's not that hard. We're at a disadvantage here. We have limited emergency medical services. 6 minutes without circulating blood, you are dead. We don't have 6 minutes here. We have ourselves to depend on it. And I think the number of people that are in this village and that can act rapidly for positive outcomes, we need AEDs in every government building. We need AEDs in businesses downtown where people frequent. We don't have time to talk about this anymore. One person in this community has been fortunate that a police officer was available with an AED in his trunk. That's like phenomenal results. And he went back to work. He was down. So if we're going to spend some money, and we have a little extra money in this community block grant, we got to make this a priority in this village.
How much does an AED cost?
$1,500 a year.
I think there are grants
We don't
available.
have an AED in town hall.
There are grants available.
Police
for that.
carry it around in the car.
Can we purchase one? Like,
No, you've got to sign up with a provider, you've got to have the training program. I mean, there's certain things that you have to do in order to, you just can't go out.
Just can't have them on the wall.
But on the other hand, I know, I totally agree. In fact, we looked at to it, but you've got to get training programs.
Honestly, I'm like shocked. I thought we had one here.
No.
Can we make a motion to like buy one, not right now?
You gotta have the.
I don't know.
You can't buy one without the.
Well, I think we should
do that.
Let's get it done, yeah.
But wasn't there something recently about grants available for
Oh,
this?
there was at one
Yeah.
point, in fact, I was
What
a
happened?
trainer at one point,
Yeah.
but, you know, I don't have that certification any longer.
I mean, I would say like for $1,500 when we don't have an AED, just don't even go for a grant, just spend the money and get it.
No.
Purchase it.
Right.
I'm not saying
You gotta go through a process.
do it like
Yeah.
this
Yeah.
board meeting, but maybe like really.
First of all, you have the people, you have to have the people that are trained to be able to use it.
I-
It doesn't,
yeah,
it doesn't do any good to have
American Red Cross will provide
the
that.
machines if
kill
nobody's
somebody.
here is trained.
I mean, I don't currently have, I let it lapse unfortunately, but I was a certified EMT for 3 years. And unfortunately, I should have kept up with the continuing medical education courses, but I kind of lost track of time and let it lapse. But I definitely know how to use an
But the
AED.
American Red Cross, I'm sure, are able to provide us with something, so we
We
gotta
okay, I'm gonna take off.
try to move on this a little bit.
Thank you, Mark.
If the town could at least make an effort to research how we can get this effort started, because we're wasting time.
If I had $15 that I could spend on AED, I would buy one, but I'm a little, I think we should look into that for the next board meeting.
Any other comments?
George? Yeah, I just wanted to respond to a couple of the comments. First, I wanted to respond to Chris Regan about, this is an issue of transparency and how government is conducted. And I do think that the greatest amount of transparency is desirable. Therefore, I think the open meetings law is very well intended, and we should be trying to do everything we can to be as open as humanly possible. I think it is unfortunate that we live at a time when, as Ralph mentioned, when trust is not there in some degrees. But that's the way it is. That's the way the world is. And I think that the way that we address that is by showing what we're doing. The issues that we grapple with here are not cosmic. They're very, meat and potatoes. But I do think it's important that people feel that they know what we're doing. And I do think one of the ways that has been mentioned several times tonight that we can do that is by being very specific about what it is that we are going to talk about if we are either in executive session, A through G on the list, section 105, or, if it's going into attorney-client meeting. And I think that will go a long way. I wanted to respond to Rachel's question, which was like give an example of what you would be talking about. Well, if somebody let's say somebody disputes their taxes, okay, and they go to the grievance thing, and they're not happy. They decide, well, we're going to sue the town. We're going to bring
For attorney-client.
Yes.
Okay, thank you.
Okay? We're gonna go after we're gonna just take it to court. And let's say that the amount, is relatively small. You might find that, as representatives of the taxpayers, that we're gonna spend more on the attorneys to fight this action than if we agree and settle. Or it might be the other way around. But that is the kind of conversation that you really can't have in public because you don't want that person, that knowledge to be out there. I'm trying to give you a
Thank you.
hypothetical example.
That wouldn't fit under A through G as far as.
No, that would be an attorney-client.
Well, that could be.
No, that
That would be a litigation.
That would be pending litigation.
So,
So
Yes,
it
yeah.
wouldn't, so that's what I think there's some
Well,
confusion about.
there's a lot of confusion
is
between
why
the attorney-client.
A through G those are really broad categories.
unfortunately, our attorney is not here,
Yeah.
but we're trying to answer the questions. But
I'm just trying to be
That was a good-
responsive.
Right, so, and I had a response to that, does that not fit under litigation? I know the attorney,
Yeah.
so.
No,
so
I understand.
I'd love to hear the rest of what Chris is.
It's item D, which says
yeah.
discussions regarding proposed pending or current litigation. If your attorney's in the room with you, is that not then attorney-client. Anyway, it gets
Right.
very, I don't want to get into the weeds
Executive session.
about this. But I'm trying to give you an example of a conversation whichever one it is, it's in, is necessary really not to have in public.
Well, I understand that, but I was specifically asking about attorney-client, because
Right.
that was getting confusing for me, and the fact that you could meet at any time to do that when we're talking about more than two members doing
Yeah.
town business would be, not legal,
Yeah.
actually. So it was the attorney-client, and I've reviewed the A through G and thought, wow, those are really broad, and so much goes under that. So when really are examples that would be clear that it would be attorney-client need for a board to meet?
Yeah.
Yeah, and so thank you though.
I think
I think it's hard to know.
Yeah.
But it isn't, that would be litigation. That doesn't seem hard at all.
Yeah. No, I personally, Warren's not here, but I need more clarification as to what exactly are the rules for attorney-client session. I know them for executive session, but I just personally need more legal advice on what are the parameters that would permit us to enter into attorney-client session, and we can discuss it, I guess, when Warren is back here next month.
But this is why I was saying in response to what Chris was saying, the least that we can do that, either of those, I think is
Well, and I
desirable.
guess the spirit of the law is that you should use either of those non-public gatherings as little as you can.
Yeah, and I think that's what Bill was saying.
The idea is to, even when you're getting legal advice from him, if it isn't legal advice that has to be done in private, the spirit of the law is that you should be doing that in public. And tonight, you guys got legal advice from him. You got his opinion on things, but we got to hear it, and we got to see everything involved.
I hate to ask you this stupid question, but what's the difference between that and a workshop? What are you discussing in a workshop when it falls under the contents of a workshop?
Workshop's a public meeting though.
It's public.
Yeah, correct me if I'm wrong, but
It's a workshop is an open meeting for anybody to attend. The only thing is that normally you're discussing some type of issue, some type of project, some type of, it could be most anything.
But it's open to.
But it's open to the public, except that it gives the board members a chance to discuss it among themselves without the public having the ability to be able to enter in on the conversation.
But you can sit at this table, you can come and witness it. I haven't been videotaping that because it requires kind of a production and, volunteers to do it, so, it's posted, people can come to town hall and witness those.
When's the next one?
Workshops? Workshops are normally done on a case-by-case basis. They're done as needed.
There aren't any scheduled at the moment.
There aren't any scheduled at the current time.
I have one other question about something you were talking about, the seeker process and establishing lead agency on that. When we're working with the town and the village together, and I know we're always hunting for the best avenue for money, if you're working on something in conjunction with the village and you assume lead agency, doesn't that, or agree to be lead agency, doesn't that allow, the village is allowing you to act as the primary party? And
Basically, yes.
so when we're going after grant money, do we fall in it, and we're supposed to be doing shared services as an approach to everything, I would assume?
Well, those things that there is a joint need between, where there's an overlap
At
of some
times, is
type.
it better to be a single entity for village versus town? Or does it
Probably-
work better if we're merged together as much as possible?
You stand a better chance in gaining a grant normally as a joint, more than one. It's just that when they look at the grants, if you have both a town and a village going in on the same grant, you're probably going to get a higher priority than somebody who's going in singly.
So if we erase the village, just hypothetically, and because that's my dream, but if we erase the village and made it a town, our potential for getting the amount of grant money we're approaching is less?
That's a
Or-
possibility.
So the governor's saying, I don't want this anymore, we have to go away, the village has got to go away. Is there a way that we could prove that our needs are the same as to municipalities existing the way we are?
Joining two municipalities, joining with some other municipality on it if you can, if it is a need that overlaps, you know, those two things is a possibility, I suppose. But, and it's kind of funny the way that the system is, yes. You're right in saying that, you know, because we are a town and a village separate, that when we go in for grants, we stand more of a chance of getting it that way.
So for instance, on the composting toilet one that I was talking about,
Yeah.
that was, we did that, that was the village and the town, but the village was the lead on that one.
Yeah.
And the fact that the town supported it helped it, and we got it.
Yeah.
And, yeah.
I'll make sure you're invited to the dedication.
It depends. Right now, the village has some things that they're looking into that we may possibly go along with them on a grant proposal, and in which they would be the lead. But it depends on who really, I guess, is the larger benefactor of the, you know, of whatever grant you're going for. Anything else? If not, can I have a motion to adjourn?
Motion to adjourn.
Made by John Midwood, seconded by, don't everybody jump in?
Right here.
Ralph Fidelli. All in favor?
Aye.
Aye. Okay.
Thank you.